Bam!
Get on down. Gotta get up, gotta get up, gotta get up. Get on down.
All right. We got to get up, get on down. All right, we got to get up, get on down. And then it says, sit the hell back down. I think that's telling them, I'm thinking, to sit the hell back down. Yeah, so you people who you people who call me on the day that we're having a live stream, like a few hours, 3 hours, like at noon after lunch before the live stream, and y'all be telling me I'm harsh and ask me what the hell I'm talking about and telling me I'm mean and stuff. All right, because I'm jamming. Okay, when y'all calling me, I had to shut off the music. All right. Okay, so that's only for the people who already been told at the gate what the game plan is. When you communicate with me, especially in the premium package for the coaching at the gate, I give you the whole game plan. Yeah, I tell you they're going to try and dismiss your shit. They're going to try to throw it out. They're not going to provide the finding of facts and the conclusions of law. No judge does. And you do supplemental pleading, jam their ass up. Then we just learned that we got to have the new document that we got on the website objecting to the judges, so we have to object in 2 different pleadings. Okay, one has to be a procedural objection. The other pleading has to be the substantial, which is actually a lawsuit for that shit. Okay, yeah, we got those 2 on the table too, and I tell people about them because when you invest in a premium package, you get all that. Okay, but then what happens is people add the lender or they don't think that they should file something because it says that the judge made a decision or something, and the judge hasn't done that yet. Hasn't done that yet, but the judge is going to do that shit down the road and a little. Not yet. Okay, I'm like, okay, time out, all right, hang on. Because I'm like, I think the best time to object to some judges' stuff, is before they do it. Come on now, work with me here, okay? You people who think the other way need to get y'all head out the conventional program of bullshit where you got to prove this, have everything right. You don't have to have everything right. You just have to have their ass set on fire. I'm just saying. It could be one thing in the whole document. It could be one thing in the whole document. It could be one thing in the whole document that crushes them. One thing. And now, I'm talking one thing in my document, okay? Just so you understand what I'm saying. Because there's more than one thing in my document. It could be one thing in the document that crushes them, but people are worried about the one thing that they think is not right. All right, for you people, let me tell you something. If that's what they're going to object to, then if I'm the one coaching you and you're not coaching your damn self, okay, then what we're going to do is just move straight for default judgment. Because if they're going to nitpick that one stinking thing that they think is a mistake or whatever, they ain't object to the shit else. And they can't answer to your stuff. It's either all in or all in. No, come on now. I'm just saying. Ow. So, the best thing to do is to do what the coach said to do. Because the coach is giving people advice based off the real-time feedback from people that been in the ring punching these fools in the face for a long time, for a while. All right? The real-time feedback from them is what we're doing. So you can do a check down because 2 or 3 words ain't right that don't match up in your head. But you need to understand that the stuff in your head is the crap that you were indoctrinated to believe, that you were learned as you're growing up. You learned that as you were growing up. And you were taught that from bar members or bar member employees or people from the corporation that was getting paid from the bar. I think you understand what I'm saying. I think you understand what I'm saying. Okay, so I just tell people to chunk that shit at the curb. You can't bring none of that shit to the table over here, okay? Because if you put that shit on the table, or like in the last video, we was up on the judge's bench. We ain't on the we ain't on the damn table no more. Okay, but anyway, it just starts to stinking. Okay, and I used to box and I played football. I did martial. I did all this crazy shit till I had to have nasal reconstruction. I don't like the smell stink. I know y'all ass don't either, because right when you start smelling the stink comes the fire. No me gusta pinche fuego. Okay, fuego pesta mal mucho más. Más mucho. Okay, so the fire burning the poop smells worse. Okay, it smells badder. Maybe I can make that into a word. I'll work on that. Let's stay focused. Welcome to the show. Rosso. ¿Cómo está, Gavison? I mean, Rosso. Oh, yo lo siento. Yo lo siento. Okay, sorry. I'm saying I'm talking ghetto language over here. So I need to keep up. So yeah, welcome to wherever the hell we are right now. We about to bust some people in they're gonna be real mad. That's why I'm in the situation room. I was wanting to do this in the judges in the courtroom thing. They said, no, you need to be in the situation room in case there's a situation. Okay, but you know what? This thing that we're talking about already has been marked down. Now, I said I know where I said it was going to be when I posted the thing, but I promised Legal Lily and Coach Karen, and I promised those two that we would give y'all a better deal. Okay, and so Legal Lily and Coach Karen, I think they teamed up on my ass of what I think happened. Okay, because it just didn't it just didn't go right. I mean, after the fact. Okay, but the point was made because, so Karen and Legal Lily, I think they've been working on critical thinking stuff or something. And so, they're like, well, why are we here? Are we here to help people with cake? Okay, well, Okay, but and they both were telling, both Legal Lily and Karen both was telling me, we gotta give them the best deal should go to the people. Okay, so what they said was, and I'm just gonna throw it on the table, okay, because I can clean it up, but it's still gonna be the same. Okay. They said that I should give the people the best deal that shows up and listens to my stuff, but they didn't say stuff. I think Lily, no, Karen. Okay, anyway, so so I said, you know what? If y'all gonna like tag team or whatever over there and be doing all this stuff, I'll just let y'all handle that. So they went and marked it down. I don't know. We'll look at it later because I want to show you the package. And I don't know what the hell they marked it down to. I was coming to the table. Well, it's a premium package, a custom premium package product, basically is what it is. So it's the same price as the custom packages that people pay me to do myself for them. And also, I was trying to, I'm thinking I was getting worked a couple of days ago because Lily was telling me, Legal Lily, oh, she's over there napping now. Okay, she was telling me I should give everybody at least half price deal. So I set it up for $900 half price. I'm all right. It makes sense. And then later on, then it came up that I should give the people that's here on YouTube a better price, basically. But they didn't put it that way. They was, I had my toilet paper because they had me in tears. Okay, so I got called a harsh coach today because someone didn't remember what they said, and I was not happy about it because I was busy. So I was using that for the tears from being harsh. Okay. Okay, never mind. Never mind. I did get called a harsh coach. Okay, but I've been called some worse shit. And as long as people are still in their house or houses or the hell out of jail or whatever the hell the situation is, I ain't trying to back nobody specifically. I want you to be straight with me and tell them what you think. And I told this person that they should leave that in the comment. They should. That I'm a harsh ass coach when you ain't doing what the hell you supposed to be doing, because that's what it's for. He admitted that he remembered me telling him what I had to tell him from 4 or 5, So I just, it's a time thing. You can't get the time back. And, when I was young, I never thought about the time. Or maybe when I was poorer. Okay, never mind. Let's move on. We're going to just... hello, Heather. We haven't seen you for a little while. Welcome to the show. Grosso. Okay, so let's just get rolling here. So, we've been learning how to do things differently in a different way. And working with other people, the real-time feedback, remember? We talked about that. Okay, has opened the door to some stuff. Now, I was working with another coach, and then we came up, that person used this subrogation and release of mortgage in their game plan and their strategy. And the attorneys were like, oh, they were trying to get the judge to have an ex parte hearing without her there, and it put that right in the letter. That it wasn't anything that was filed there, it was the letter. And so what we learned was the subrogation and mortgage release situation is off the chain. Now, I spoke with this coach before I got all this stuff together, and I'm reading all the documentation that she sent me because when I do a custom job, I charge $1,700 for a custom job. I go through the documents, I figure out what's going on, I write the response, and then it's her job or your job to keep up with them if they want to respond back. And you get one response free. After that, $75 for a response if they can respond well the first time. I'm not bragging. I'm not. Okay, maybe I am. Okay. This is what I use to pat myself on the back because it's kind of hard to reach all the way back there. I might be. Okay, never mind. So let's. Oh, yeah. I love bringing fire to the table. We had that attorney that was here, attorney injury law attorney that was here a few weeks back that was giving us a hard time. I'm thinking about inviting him back because he'd really be having a hard time what we got going on right now. Okay, so this subrogation situation is like fire, and what the coach had that brought us to the table was this thing based on the fact that they're not. That they were denying their corporate existence, the straw man, all capital, and it was strong. It was holding them off, and they were trying to figure out how to get around it. And then she came to me, and then I did my research. I had to call her to figure out what it was because they didn't mention it. They didn't put a copy of it in there when she told me what it was. I wrote the word down and I looked it up myself. And then I put together the one that we have now, the inventory one. And what we've done is connected the dots to the real estate deed fraud and all the stuff that happened after you left the signing table. The 6 missing things that we address in the premium foreclosure defense package, the $1,500 package. Okay. How we connected. Well, actually, we connected more because what we done with ours now, the way I see this, if you bring a notice, okay, then and you're in an administrative court, okay. So we'll just say if you're in a judicial court, so you can understand this better. If you're in judicial court and you bring a notice, the court, and you're bringing judicial notice of undisputed administrative facts. Or if you place a notice in the public record, okay, that notice is placed on the public record to let everybody know. Now, they ignore it. So you do a judicial notice that you got this notice plugged in the notice plugged over here in the and file that in the court. Okay, so when the court ignores your judicial notice, they just violate your due process. Okay, so let's just go a step further. The court's pulling the wool over our faces, over y'all, over some people's faces, not y'all here, okay? The court's pulling the wool over people's faces, making them think they're in a judicial court. When you're in court, you thought you had some rights. You did when you went into the court until they started. Okay, well, anyway, okay, but you don't have no rights because you're not in judicial court. You're in administrative court, but they want you to think you're in a judicial court. Okay, so wait. Hold on. Time out. I'm not that smart. So if they're going to drag my happy ass in their administrative court and make me think they're in the judicial court, which set of rules do I want to make their ass follow? Their administrative rules that they came up with at each location by the bar members that are screwing you over? Or do you want to make them follow the rules for the judicial court that they're telling you that your ass is in? Oh, could it be that simple? Could it be that simple? I asked the question, okay? Because they telling me, oh, it's conclusatory. You don't know what you're talking about. You can't read the stinking shit from the Supreme Court, Swear versus Board of Examiners, that says that attorneys don't have a license to practice law. Okay? All have is bar card and a certificate. The certificate is from the state. It doesn't mean shit. The bar card from their own RICO corporation, gang affiliate, whatever, and it don't mean shit either. That's all they got. Oh, but they can get away with that. Oh, because they're all on the same team. And this subrogation and mortgage release situation is bringing us some whole new shit to the table. Okay, these new documents that we got on the website now are like, it's like a new class of punching their ass. It's like a nuclear ass punching in the ass. I don't know, y'all call it. We gotta work that out. Okay, but I'm just saying. Okay, so the way this shit usually goes is most people's shit just moves forward, and no one is forced to prove shit. I mean anything. No one's forced to prove anything on the record. That's and if you're a homeowner, defendant, or someone in foreclosure watching the process move faster and faster, then you can control this is exactly what's happening. You're watching the case move. Filings go in, deadlines are set, decisions start stacking up, your stuff's ignored. They have all of the excuses. They make you jump through these hoops. They keep making you jump through these hoops, and then hoop your ass right out the back door. That's what they do. And nobody's been forced to prove anything. Nobody's been forced to prove shit. No deed, no verified accounting, no legal authority. That's not because it doesn't matter. It's because nobody forced it into the record. That's how the foreclosure cases move. Not on proof, on process. The illegal administrative court process connected to statutes and codes that are not valid laws. Statutes and codes are not valid laws. They don't have enacting clauses, titles, or bodies. They're not connected to the Constitution. I don't have to follow shit that's not connected to the Constitution unless I'm a U.S. citizen. But I'm not a U.S. citizen, and nobody can be a damn U.S. citizen because nobody can be born in a damn fake-ass corporation. There, I said it. Oh, that pisses some people off. You're a citizen of a republic state where you were born. That's how I look at it. Some people say you're sovereign shit, whatever. Well, I don't like to use words that I can't spell. So I didn't know how to spell sovereign shit. I had to look that shit up when I spell. I can spell I'm a citizen of the Republic State of Arizona where I was born. So I can spell that part. I like to keep it simple. I'm not that smart. Okay, I did a bunch of stupid shit. And so keeping it simple alleviates, removes, congregate. There ain't no arguing. When you keep it simple, there ain't nothing to argue. Oh, wait. When you bring the facts to the table, there ain't no arguing. Nobody wants to argue the facts, Jack, because that's that. Nobody wants their name on anything that's factual. Oh, coach, I'm missing 2 words that reflect that the judge said something that the judge didn't say. But all the rest of the shit's factual. Okay, so if it's factual, can they argue? Hell no. If it's factual, do they want their name on it? Hell no. Why? Because they don't want everybody else to see that they signed some shit. And I'm talking everybody else. I'm talking their buddies. Okay, I ain't talking about y'all ass. I don't give a shit about y'all asses. Okay, stay with me. I'm talking about their buddies. They don't want their buddies to see if they signed their name, and I'm talking about the judge, okay, on some shit that outlines what's really going on. And now it becomes not case law. I know that's what you're thinking. That's bullshit. It becomes precedence. Uh-huh. That's what we're operating off of today, precedence. Okay, so what precedence from their Supreme Court decisions? Oh, the Supreme Court that makes the rules for the local courts. Yep, that's the same one right there that I'm talking about. And those rules that they make ain't connected to the Constitution. The state Supreme Court and the federal, neither one of them are connected to the Constitution. Oh, but they're making the rules. Uh-huh. They're making the rules. What they're connected to is their offshore bank accounts, their time. Okay, so that's my opinion. Sorry. They ain't connected to the Constitution. I know that for a fact. And most people, and a lot of people have a hard time understanding that the court rules are administrative and total bullshit. And they keep running around trying to get things together so they can convince the court. Sometime in the eviction court judge will just tell you, I can't do a counterclaim. I can't, this ain't a court. They'll just tell you, I can't do a counterclaim. They're not going to tell you why. Okay, so if you keep talking shit and pushing the eviction court judge to do the counterclaim, and you're doing a counterclaim against somebody that buys these stolen properties from them, from the state on a regular basis, okay, then what's going to happen? Oh, and they're going to like have a meeting in the back room. No, we can't let this person sue her because then she's going to lose some of her properties. And then we're going to take the hit. We, the state's going to take the hit because they're the ones that stole your shit. I mean, I don't know. I'm just saying that's how I got it in my head. They said I was mentally ill, and then my kids been telling me I was crazy, and then Max, a lot of people told me I'm crazy. Maybe it's like the fox. I don't know what that means. Okay, my grandma used to say that. I don't know. But I know the system is not set up to help any of you. And people don't understand that you have to stop the state court process by adding the players to their own shit. You add the state to it. You add the stinking judge to it. You add the, to your counterclaim. You file that. Okay, coach, but you just said a counterclaim. Yeah, I did. You file that in the shit to blow up their crap. And then you get your lawsuit filed in federal court. Okay, that's how we been. Now, if you're in state court and not the eviction court, then we have the objection to dismissal package, where you have your objection to the procedural bullshit, and then you have your objection, your substantive due process claim, which is how we have not been doing it correctly. And that's how you attack the state court judgment against you. It has the objection to the due process violation. It has objected to the procedural violation. Well, actually, object to the procedural violation and the due process lawsuit is all in one. I think it's like $149. If the judge ever dismissed your stuff, objected to your stuff or whatever, $149, or I think it's $140. I don't know. Okay. But people don't take the time to go read the stuff, check out the new stuff, whatever. And so they miss out on a whole bunch of shit. So that's what we're going to say. So most people respond. They answer the complaints. They file motions. They argue pieces of the claim. But the structure never changes. You're still sitting inside their system, reacting, still trying to slow something down that was already moving and paid for and structured to do what it's doing. And it just keeps moving forward. It keeps moving forward while you're doing that. That, whatever that is moving forward. Defense reacts to filings. They force these force responses. Defense argues the claim. This requires the claim to be proven to be taken back from the lender position. Okay? That's what subrogation is. Putting yourself in the lender position. Oh! I wish I thought this long ass time ago. But you know what? Everybody would have been burned up by then, and we would have nothing to do now. That's how I'm looking at it. That's how I'm looking at it. Okay? So when this requires a claim to be proven to be taken back, to take back the lender position. Oh, defense follows the case. Subrogation changes how the case moves and where the hell it goes and who's in the driver's seat. Burning stuff. All right. Who's in the driver's seat burning stuff? Okay, what segregation means is stepping into the right to enforce a claim instead of responding to it. Bam. Oh. In most situations, subrogation is tied to one party stepping into the rights of another party after an obligation has been satisfied. Okay, hold it right there. Hold right there. Remember, okay, we ain't got time to go all the way back to the gate. But remember, at the gate, you signed that shit. The bank didn't sign anywhere at the time. Okay? You signed, the bank didn't sign anywhere. After you left the table, the bank stamp paid your order up here and signed some stuff without recourse and did some crap and turned it into, all right, so that whole thing was generated, the electronic credits were generated with your signature. People, the obligation, you are the obligee, Okay, let's just move on. Your signature created the electronic credits alleged as the mortgage loan. And it's commonly used as insurance or in financial situations. The subrogation is used like in insurance claim or in other financial situations, and where someone pays and then takes position to enforce. And that's the traditional use. Okay, but see, here's a check down. Here's the punch in the face, and this is, I don't like to do the knockout because I like to make them quit. I like to make them give the hell up. Okay, that's a whole lot more fun than doing a knockout. It's a whole lot more fun than going to arbitration. It's a whole lot more. I just like to make them quit. So here's the quit. I'm supposed to say, here's the change, here's the shift, here's where the control. No, here's the quit. Instead of using the subrogation as a passive concept, it's been used as action position inside the case. Now, generally, when you do a notice, a subrogation and lien release, you're saying you want to do a notice based off of this. And in the original case that brought this to my attention, they're saying they want to do this because you're not a U.S. citizen, you're whatever, and that was cool. But we're bringing it to the table based off the accounting shit, the unverified accounting issues. Okay, like the OIG 1099. There's like 5 or 6 documents. We never had to mention the documents in the document that we made. Okay, because we gotta save a little fire in case they figure out some kind of way to get around. Oh hell no! I'm saving the fire anyway. But I don't know. Maybe there's some way they'll get around. I don't know. I'm throwing it out there. Okay, any attorneys that can come to the table and crush this shit or any of my shit, ring me up, hit me up, send me an email. I'll send you a link. You come on the show. You crush my shit, I'm gonna give you some free shit off the show, or I'll go to your show and kiss your ass. I'm throwing it on the table. Bring the fire, though. Don't come here and talking no trash without bringing the fire, because we're going to burn your... All right. I'm getting a little... I got my pink shirt on tonight. I got my gold nails, butter finger. I mean, gold finger. Okay, so instead of staying in defense, you step into enforcement authority. You step into the enforcement authority. They don't call you the Godfather. The head drug. Okay, never mind. Let's stay. Let's stay focused. You're no longer limited to responding to what has been filed. All right. You are placing requirements on the record that must be addressed before the case can move forward. Now, we talk about this a lot. You ain't got to win your whole case tonight. All you got to do, bam, is stop the next step, the next move. Jam them in the face so they can't remember what the hell they're supposed to be doing. That's all you got to do. That's what this gives you the ability to do that. The claim itself creates the opening. And so basically how this works, just in case y'all ain't keeping up with me, when you file a notice of claim and release of subrogation, the notice of subrogation and release of mortgage lien, you're moving yourself in the lender position. And you're saying that the stuff's already been satisfied. It needs to be, the accounting and all that stuff needs to be bam, and the deed needs to be delivered. Now, what's that mean? Well, when you do it on a notice or a judicial notice inside the case, it means now they have to turn the case into a judicial case instead of an administrative bullshit. And they have to respond or do something. They can't, because you have them punched in the face. So basically, the situation that you have, that you created, is in order for them to take back the position as the lender, they have to prove all the shit that everybody's been asking them to prove. They have to verify the accounting. They have to show it with the original instrument of indebtedness and its original form. They have to with no additional writing on it, writing stuff on it that was not on there before your ass left the table. That's in its original form. Okay, before you left the table, it was in its original form. After you left the table, and all this funky stuff they did was not in its original form. They had to come up with all of that. Now, I know what you're saying. Coach, they're just going to ignore it. I already know they're going to ignore it. And I told the dude that told me I was harsh, I told him this shit a long time ago, too. They're going to ignore it. That's when you hit the ass up with the objection to the dismissal, object to, and then you file your substantive, But in this case, I already know there was, because that's all, they can't respond to the judicial stuff in an administrative court. They can't respond to stuff connected to the Constitution in an administrative court. So I already know that. So when they ignore it, then you have another document in there, the 2-set document that we've been talking about at the gate, to object to the procedural crap, and then your substantive due process, to sue them for ignoring your notice. If they ignore your notice, it's a violation of your due process in a huge ass way. So we got that in there for that. So, you place your notice on a public record, or you turn it into a judicial notice, and then when you return to judicial notice, you attach a copy of the notice that you have filed in the public record to it. Bam! Add a little more heat to the fire, throw some gasoline in the face. On the feet. Yeah, we don't want to throw it in. We don't throw it on the feet because you want to. All right, I'm just going to say it. You want to enjoy watching the ass burn. Well, that's what I tell you here. When you get in my program, you're going to learn how to have fun. Okay, that's what you're going to learn how to have some fun. And you can't do that if you've been a sissy ass. Or if you're not following what the hell the coach is telling you to do and you're coaching your damn self. So if someone's trying to enforce the mortgage, they must rely on specific elements to do that. And that includes, delivery of the deed, a full and verified accounting of the accounting, proof of authority to enforce the accounting, unbroken chain of title, and there's like 5 or 6 more. And you're not creating new requirements. You're forcing the claim to meet the requirements that it already depends on. And so how does this apply to my position? In a foreclosure case, enforcement is everything. If the party bringing the claim can demonstrate control of the deed, then it cannot be. And if they can't produce the deed and full verifying and full verification of the accounting, or they cannot prove authority or standing to bring, well, okay, I know what you're saying, Coach. Okay, but they don't. No, I know. Just let me finish. Subrogation is being used to bring those elements forward and require this to be addressed. And it requires it to be addressed because you remove the lender and put yourself in the lender's position. And now, if they want to remove you out of the lender's position to put themselves back in the lender's position, bam! And now they got to prove all of this stuff. And they can't. This is a real fire right here. I do. My dad was a Marine. That's what they used to say right before the blow up shit. So I didn't know. So after you file this, the moment it hits the record or place it on the public record, okay, the case is no longer clean. Now the requirements attached to the claim are not the requirement they can not that not yeah, you know what I'm saying? Now the other side cannot just keep moving forward without addressing them. Now you force them to visualize their shared liability. Not only that, you snatch the rug out from underneath their ass. Oh, could you do that with a notice? I got 2 people lining their ass up right now. And the first 5 people getting a deal. Okay, they getting the deal of the deal, a dealer of the deal. I don't even know what the deal is. They marked this shit. We'll look at that in a minute. Yeah, but the first 5 people that get in this program, that did this, and you gotta call me, and you gotta see where you at on the list to get the deal if you're interested. And I'll be up late tonight because I gotta talk to my friend Karen to see if we made any money from this deal that her and Lily made. Okay, so anyway, so the court now the court has something in front of it that must be responded to. The process shifts from automatic movement to conditional movement. And this creates pressure when you force the deed. A lot of cases don't. We already know the deed's not clean. Okay? When you force the accounting, a lot of cases, they can't produce the full accounting because of the way the process is set up. And when you force authority, it's not there because of all the stuff that we just got done talking about. That's where the pressure comes from. Nothing's in place for them to verify that there was a lender. There was not a lender. And if you put that there was a lender on your shit, then that's probably why they're ignoring you. There was no lender. The alleged loan was generated with your signature, and after you left the table, they turned that shit into a security, stamp paid to an order of on it, and with that recourse, blah, 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 blah. And a bank vice president or Linda Green, and there's one other famous robo signer is that was in it. Sign that shit, process to the Federal Reserve. And modern money mechanics, a publication put out by these white dudes. I'm just assuming they're white dudes. So. Okay. You read, okay. By these dudes, or maybe they were white girls. Okay, sorry. I'm trying to leave the girls out. Okay, and they said that these fools were granted 9 times the amount that went into a demand deposit account. I'm like, are you kidding me? 9 times the amount. Okay, I can't keep up with that math. 9 times the amount at the gate, and then they took it back from the people so they could sell it again. So that's 10 times, and the people paid for it. No matter how much you paid, they didn't give you any of your money back. Did you give anybody any money back? Hell no. That's 10 or 11 times it took. Not times not equals not. Damn, that's some Jeffro Bodine shit. I cannot keep up with that. That's where the pressure comes from. You're not arguing, forcing the claim to stand on something real. Forcing them to visualize their shared liability. If nothing changes, your case keeps moving the same way. More filings, more deadlines, more ignoring more hoops for you to jump through to be hooped your ass right out the back door. No proof, no interruptions. And now people wonder how did he lose control of the case? Well, the whole system is set up where you have no control of the case. That's why we don't play in that shit. Jam their ass up, move over here to the non-conventional program. When they can't perform, it's a problem. And if you bring the fire right, if they can't perform here, it's a problem. Okay, they can't deliver the deed, the original deed in its original. You know what I'm saying? Don't make me do a check down here. People say, "Oh, well, I got a copy. I got my deed." No, you got a copy of your shit, unless your property was handed down in your family 100 years ago. I'm still probably saying it's a copy. I'm sorry. And and they can't produce a full accounting of verify. Okay, we'll just go with a full accounting. We don't even say verifiable accounting or anything. we just say a partial accounting. They can't verify shit. Okay, so if they can't prove authority, well, if they can't prove none of the other stuff that we just talked about, they can't. Their claim weakens. No, it was already weak. It was already weak. The problem was that y'all ass were punching it inside their weak shit, which means that they don't feel the punches. They punch that shit outside over here. If the foundation breaks, then the case is shit. I mean shifts. Said the wrong word. Oh, yeah. The foundation is what we attack around here, not the stuff. I was going to say shit again. No, not the stuff. We want to attack why. Why they're able to jack with you so easy. That's why. Why, not what they did. Everybody want to talk about what they did, what I filed. Well, none of that shit matters. We ain't arguing over this. If you do, that's all I want to talk about. So this is where the path to the mortgage release comes in. What you're actually doing, you're not fighting harder. You're changing the structure. You're stepping out of reaction into control. You're deciding what must be addressed next. This is an offensive move. Okay, this is an offensive move. When you step into the place as the lender, and in order that the accounting has been settled, and the deed must be delivered. Then they have to prove that you're wrong. Now they file, you don't have to respond because they're not going to be able to file. They're not going. They're going. This whole thing's going to be on a different program. You assert, they must respond. The court must address it. You're not waiting for the next move anymore. You're creating the next move and throwing the ass out the door. Before the next step happens, okay, you got to step in and do your thing before the next step happens, before the next hearing, before the next filing, before the next step in your case happens. You either step in and force this, or the process proceeds, keeps moving without you. Keeps moving without you. And this here avoids the whole court process. I mean, I don't know. I mean, maybe there might be a little process if you're already in court. If you're not in court, yeah, this will work too. What if you're not even in default or behind? Or you're just sick of giving them your money when you know you're getting jacked up? Oh. Maybe you know this is coming because you had a medical emergency, you had a situation in the family. You had to use that money that you saved for the property tax. That's what you were going to save for the. Well, you know what? Now you can move yourself in the lender position, and if they can't prove that they should be there, could it be that easy? And I know people, how many of you want? We ain't got time for that shit. Because this is, Pro Se Lawsuit Center. We bring affordable documents and shit people ain't never seen before to help them bring fire to the table, to the judge's bench. We on the judge's bench right now. We on the judge's bench right now because your case is already moving, and it'll keep moving the same way it has been unless something forces it to change. So, how about, could it be cooler than this to put yourself in the driver's seat as a lender and make them prove that your ass don't supposed to be there, that they supposed to be there. Oh, now we're not talking about the foreclosure and the debt, the alleged debt, the debt collection tax. None of that. Uh-uh. Bam! Right there is the fire. Oh, dang it. They marked it down to $600? Lily's laying over there like she don't know anything. And I don't know, my friend Karen. I'll just have to, we'll just, that's all right. We're just going to leave it right there. We're going to leave it right there for the rest of the month. This end of the month sale. Every month, we're going to have a fire sale, and this is what they told me I need to give away some shit. That's what they told me. Well, when they got done, they asked me to summarize, and I said, we need to give away some shit. I know, but I'm down with it. I'm down with it because anybody to get this shit this cheap need to be leaving me a couple of video reviews in the video review playlist. That's where all of the fire is from people that have been burning people with the stuff they've been getting, whatever. Okay, and I like a video review after you read the documents when you first get the package about the fire that you thought you had or didn't have. Okay, and then I like the second video review how they acted when you took the shit down there and started burning it and started fouling their ass. Sorry, I get a little worked up. Grew up in the hood, I get a little worked up. All right, let's just go with it. Yeah, I want to know if they treat your ass any different when you start burning the ass with the real fire that you get from it. That's what I want to know. I want other people to know that too. Okay, now I don't give a shit about the end because I already know how the end is going to end if you do this the way that you're supposed to be doing it. I already know. The end is going to be they're going to make your ass sign non-disclosure statement, NOD, so you can't be telling nobody how you still in your house after they jacked you up and now in the nuclear packages that we got other stuff too. We got a foreclosure defense package that addresses the foreclosure situation from a defamation perspective. Oh, and it's real. It's real. I hate to use the word cheap because I don't make nothing that don't bring the fire to burn people. Okay, but here's the thing, and this can also be used for credit card or anything else. Okay, so here's the thing. When they said that you was behind on your payments or behind on your mortgage, and they're filing foreclosure, and they posted all that shit in the public and sent it over to credit card reporting people and the real estate people and all those thieves that buy these that steal people's whatever. When all those people got the fact that they said you, then and there was no judgment against you, then these people defamed you. They defamed you. Mm-hmm. Now, this is the subrogation package still. Y'all keep up, okay? Yeah, there's the video for it. You guys can go and watch the video. Who do you add as a defendant? I'm going to direct you to the updated instructional video playlist that's in the instructional in the instructional videos. You go to the instructional video playlist and look for the updated instructional video, and it'll tell you who to add as defendant. Because if you're asking me that, then you got other questions that you need to understand before you go any further. And if you don't get this right and you add the lender, they're going to ignore your shit because somebody screwed up and didn't add the lender, or someone screwed up and added the lender, and you should not have added the lender. And I think when you add the lender, they ignore your shit because they think that you believe there was a lender. So if you say stuff to believe what they're lying or whatever, then they're doing ignoring shit because they know they have jurisdiction because there ain't no lender. There never was a lender. And if you still think there is a lender, then thank you, little Ice Man. I appreciate it. Yeah, but I can only do a couple a month because I have other stuff to have to do. So it's I had to turn some people down, but I do have a custom service, and I started doing this when they hacked my website. So they hacked my website because, well, they didn't like what we're doing, and so they shut me down for like 14 or 15 days. And so then, I started figuring out other ways to make money. So I just started my own law firm. I started my own law firm, and that's what I'm doing. Doing the shit. But, I ain't trying to like go down there and kiss nobody's butt and do all this shit. Y'all got to do the shit yourself. Now, I do put the stuff together. I do email it to them from my business email address with some of my trash, my trash talk. maybe, maybe, maybe a little bit of some trash talking in there. And then I usually include a whole bunch of extra judges and clerks and other people in email, because if you bring in the Rico to the table, then all these other people are co-conspirators. They don't really have that. They don't have to know exactly what's going on, but they do. And you ain't gonna, bro, man. The whole system is set up just, yeah. So also they're custom package $1,700, and you provide me the original document. I don't need all that other shit because we don't address why. We don't address what they did. We address why they're able to do that, what they did to you so easily. So easily. That's about it. Yep, defamation, that's nice and easy. And if you're a professional, you can just throw professional defamation in there, and that jacks up the whole program because now there's no hearing or nothing. Okay, so what do you mean? Maybe you work at a job, you're a professional at something, or maybe you don't work. You're a damn professional at not working. Yeah. You see, now we're getting back to the check down on the words. Okay, you think they're gonna be arguing? Oh well, no, she's not a professional, so we just need to pay her for the other shit down here. No, throw that professional shit on there because the difference is when you go after them professional defamation, Okay, then now it's automatic check down. There ain't no hearing and shit. You show the shit they said, and it's a wrap. We go straight to, where we like to go, to the settlement conference. That's what we demand anyway. Straight ass to the settlement conference. We ain't got time for that other shit. We don't have no time, no damn trial. Now I just scratch that shit out, right? Settlement conference underneath it. Settlement conference. Okay, because in state court, they can't respond to a damn thing that you file that you get from us. Okay, because we use federal case law and federal acts, and they can't respond with statutes and codes. Bam. Okay. Then we like to knock them silly a little more. Okay, so now, and we found out if you just add the state to the counterclaim and add the and add the judge, because the judge is getting paid by the state. Okay, and the state's the one that stole your deed and committed real estate deed fraud to get your deed, and then you add the attorney or even the lender, or not the lender, the eviction people, add them, and then you have to serve everybody. That's the mistake we were making before. We weren't serving them the counterclaim. Serve everybody counterclaim. Bam. And now you just added their asses to their own shit. I wonder why the attorney don't tell you that you could do that. Huh? You add plaintiffs to their own shit in the counterclaim, and counterclaim the ass for RICO. Counterclaim the ass for RICO. Now, they ain't gonna want to hear that or rule on it, but it's burn their asses long enough for you to get over to federal court and get the real lawsuit filed. And then you want to take a complete certified copy of the docket sheet of everything that happened over there with you over there. Not as evidence, because your ass ain't in a judicial court. You still, when you get to federal court, you still in administrative court. So you're taking that shit as exhibits to prove, why they're able to do what. That's how that goes in my head. So you guys can get over to the website. That defamation package is pretty cheap, and it's easy to keep up with. Okay, because they said you didn't pay. They said but they ain't got no proof from anything, and they can't even prove that they gave you a loan. So how they gonna be saying you didn't pay? They can't prove that you. That's the situation. Okay, guys. You guys, I got that shit marked down. You guys seen it on the website there. And it's going to be marked down for the rest of this month. So, Legal Lily want me to leave it marked down so that the poor ass people like us, the poor ass people like us can invest in it, so that I need some reviews. I need reviews how because from where I'm sitting and the homework I did done, okay, this is a wrap. There ain't no way they're getting around. So I'm waiting to see how they're gonna try and do that. All right, guys, thank you for the value of sharing your time. I need to go and move the price up a little. Okay, I'm just messing with y'all. I said what I said, and I don't be playing. So I mean, I kind of be playing, but not when I said what I said. I be playing before I said what I'm going to play about saying. Come on, y'all keep up. Okay. See you guys in the next ching chang.